Yes, good evening to everybody. Welcome to the class. And yesterday that I completed what is the topic which I completed yesterday? Yes.
Defamation.
Defamation I completed in the part 1, part 2 and part 3 that I made it very much clear. Is it part 3 or only part 2 I made it clear?
Only two parts, sir.
Only 2 parts I made it clear. And in this class we can say economic tort, it is nothing but interference with the contract and business. So read what I posted on the screen. Anyone?
Good evening to the legal fraternity. Economic torts. Fraud, tortious interference when a person intentionally damages the plaintiff's contractual or other business relationship. Conspiracy is an agreement between two or more parties to deprive a third party of legal rights or deceive a third party to obtain an illegal objective. Restraint of trade. Professor Dr. Mohammed Saheb Hussain.
Yes, these are because these charts are generally affect the economy, means money, finance. So that's why we can say separately say the economic charts, but they are generally that we will read in the law of chart 5. Number 1, here I will make it out. See, there is a charts affecting contractual and business relationship. This is the title which is there in the syllabus, but in other words, we can say it is an economic chart. And the economic charts is their name suggests they have their primary function, the production of the claimant's economic interest. They include the charts of the simple, number 1, conspiracy, number 2, inducing breach of contract, number 3, intimidation, number 4, unlawful interference with the trade, or in other words, we can also say the passing of, if I may not be mistaken. See it, of course, it comes in the fraud only, but generally that we will see in the malicious fraud suit. So these are the 5 generally that we will read in the economic chart. What is the number? 1, conspiracy. 2, inducing breach of contract. 3, intimidation. 4, unlawful interference, or we can say it is the passing of, and the 5th is malicious fraud suit. So let us see that these are the contents which I am making good. Now let us make the first with the inducing the breach of contract. That will start it. So let us see what is the inducing the breach of contract. So as I said in the introduction, there are various wrongs that affect the contractual and a business relations. These are the acts that are done knowingly without any lawful justification for the sole purpose of interfering and affecting the contractual and business relations. The interference to contractual and business relations are done through these charts. Number 1, inducing breach of a contract. So it means any act which is done intentionally without any lawful justification to induce a person to make a breach in existing contract whereby the other persons in the contract suffering damage. The case of Lumley versus Gay. So this is the case Lumley versus Gay. It shows it is an important judgment on this point. How it can induce the breach of contract. It is a classical case law, and this case law should be cited in your examination. So what is the name of the case law? Lumley versus
Gay.
Or you can say Guy, Gee, or whatever it may be there, because we don't know, because it's the person name. I don't know whether you will call it the Gee or Guy or Gee. Anyway, the G-Y-E, Gee, or Lumley versus Gee, you can say. So this case law says about the earlier, the master could be bringing an action against a person who had wrongfully deprived him of his services of his servant. And this case brought the turning point on this field of law and inducement to make a breach of contract. And what is actually the breach of contract here is a famous operatic singer. I don't know whether you know the opera. You know the opera?
Yes, sir. They will sing loudly.
Yes. Sometimes, of course, I am not blaming anything. Opera is the art of it. So there is such a cry would be there, and after that, the tone. So a famous Johanna Wagner and was having a contract to sing for the opera. So they were contracted having the singing in their theater. Who is Johanna Wagner? And these defendant induced her. So another competitor with their theater owner has induced her into make the breach of contract by paying her a large amount of the money to sing for him rather than the plaintiff. The defendant was held liable. So now the defendant came over there and want to see that the Johanna Wagner should have to sing in his theater, and he induced her I don't know whether it's her or he. See, generally the operas are sung by the female. Am I right?
Yes, sir.
Yes, generally what I say, the operas, mostly the women will sing the operas. So here, and he was induced her, and she made a breach of contract with the first plaintiff. And here the plaintiff bring an action against the defendant because you induced my one of the employee where not employee, one of the person where do you have the contract with her. So that was actually her contention, or the first plaintiff contention was that. So that is actually the thing which has happened over there. So it is nothing but the inducing the breach of a contract. At that instance, maliciously, intentionally that he did so, at the time we can say that it is the inducement made of the one of the employee or the contract person to breach the contract. So one can bring an action against the person who induced such a thing because it is an economic loss to the plaintiff. Is it or not?
Yes, sir.
Yes, a tortious act of affecting the contractual or business relation through the inducement can be committed in various ways. So, by doing a certain act which is done by one of the parties of the contract would have resulted in the breach of a time. So, knowingly performing such acts which is done by one of the parties to the contract would have resulted in the breach of a contract. So, here the knowingly, if you make a breach a contract of a particular thing, then also it comes under the inducing the breach of a contract. The decision in the case, there is a very much famous case law, that is the WK Limited Dunlop versus Dunlop Rubber Company Limited. Read, anyone can unmute and read.
Knowingly
GWK
performing such
Limited.
acts.
GWK.
Go on.
Explains this kind of interference. The plaintiff GWK Limited were the manufacturer of cars who were having a contract with A. So that the cars manufactured by the former were to be fitted with the tires manufactured by the latter. Whenever the cars were sent to exhibition, when the cars were sent to an exhibition, Dunlop Rubber Co., who was aware of the above mentioned contract, secretly replaced the tires from the two cars with the tires of their manufacturer. They were held liable towards GWK Limited for trespass to goods and towards A. Co. for interference with the contract.
A company, you are not reading the company CO. You say there in the earlier also A.
Oh.
A company is
Okay.
a particular company.
Okay.
For the interference
Okay,
with
right.
the contract. So now the question comes here. Here is WK Limited is one of the automobile manufacturing company, like MG. MG also a one manufacturing company. Then I just saw WK full form. It is a garage Vidro Payung costume. I repeat, garage Vidro Payung costume. GWK. There is a garage company, Woodruff costume company. It is the manufacturing, the automobile company. So automobile companies having a relations with another company and whose tires are sold whenever the company car is out. So now what happened here, the plaintiff GWK Limited were a manufacturer of the cars, automobiles, who are having a contract with another A company. The company name is not mentioned over there. The cars manufactured with the farmer means GWK Company Limited, fitted with the, not fitted with the fixed is good. Or we can say fixed or fitted, doesn't matter. Be fixed with the tires manufactured by the A company, with the later company. Whenever the cars were sent to the exhibition. Here, it is especially where car was sent to the exhibition, because there is an exhibition of the cars are there. I don't know whether you saw such exhibition or not. Have you seen such an exhibition where the different type of the automobile,
No,
including the old and automobiles also shown over there?
No, sir.
So now the question comes over here. When the car was sent to the exhibition, at the time, the Dunlop Rubber Company is a very famous company, Dunlop Tires. And what they did it now, he slowly, I don't know how they managed with the GWK Limited, or they managed with the A company, but doesn't matter if they managed with any one of them, means induced them to fix their Dunlop Rubber Company cars when they are sent to the exhibition. So above mentioned contract strictly replaced the tires from the two cars with the only two cars with the tires of the manufacturers, that is the Dunlop and Company. So there were held to be the towards the GWK Limited for a trespass to the goods and towards A company. Because number one, they interfered with the contract, they removed the A company's trace and replaced with the Dunlop rubber company trace, and that's why interference is made by inducing the persons over there. So this is the way, and it is a type of the inducement they made it. Hence, Dunlop rubber company is held liable to pay the compensation. Am I right?
Yes, sir.
So, by doing the certain acts which was the performance of the contract is physically impossible, or removing the tools which are required for the performance of the contract, or physically detaining one of the parties to the contract with the sole purpose of preventing the performance of the contract, these are all nothing but inducement of the contract. What are they? By doing certain acts by which the performance of the contract is physically impossible. Suppose if you destroy the subject matter of the contract become a futile, frustrated. Or removing the tools which are required for the performance of the contract, even that place also, it come under the frustration of the contract or impossible of the contract. Or physically detaining one of the parties to the contract. If you detain one of the parties to the contract over there, even that also is the amount that not to performing the contract. It is nothing but inducement of the contract. So by direct inducement, so when one can induce very directly also. Here, how we directly we can induce, let us see that. So an act by the a defendant through which he offering some kind of the temptation to one of the parties of contract for making a breach of a contract. By making some threat of harm if contract is kept alive, for instance, either by the inducement by the threat or inducement by the money. Am I right? Say yes or no.
Sir.
Say yes, sir.
Yes, sir.
We can
Yes, sir.
induce a person by threat also. We can induce a person by money also. So here, for instance, a threat of strike unless the plaintiff is dismissed or by offering some higher remuneration to a servant, then he is already receiving under the existing contract. It is also in one way, in another way, it is the inducement of the contract only. If the defendant has given a mere advice, then it would not be actionable. Suppose if he given the mere advice, whether you follow it, may not follow it, that is your issue. Are you following me? Suppose a girl breaks her contract of marriage due to her parents' advice. Both these actions are not liable for inducing a breach of a contract. Suppose, on the advice of the parents, if any girl breaks her marriage, whether it is a inducement done by the parents, yes, whether the inducement done by the parents, if the daughter breaks the promise to marry, whether the parents induced her to make it, whether the parents is held liable for the action, say, whether the parents will be held liable for the inducement of the contract.
Don't know,
No,
sir.
sir.
Answer no. Because parents know more better than the daughter. Parents know what is the future of the daughter. Daughter is merely now full busy with the lust and the lure. She doesn't think about the future planning. She thinks only the present planning. So it is not about to inducement. If the father or mother induces the daughter to breach the contract of marriage with a particular person where she was already engaged, are you following me? Only the people, bridegroom
Yes, sir.
people, if they are suffered with them financially, they can ask for only the damages, but not the specific performance. Am I right? Say
Yes, sir.
So
Yes,
now,
sir.
these are the certain qualification required for a breach of a contract or the inducement. So persuasion cannot be termed as inducing a person for a breach of contract. Suppose if you pursue a person, if he follows, may not follow, merely persuasion will not amount to the inducement of the breach of contract. There should be certain act should be done over there where the financial loss or any other commitment which supposed to be fulfilled may not be fulfilled over there. So there is no wrong or pursuing a person from not entering into a contract or terminating a substituting contract lawfully or pursuing a person to refrain from entering into a contract. Yes, one can do so. Like the case Allen versus Flood is one of the case law where it shows the inducer not to perform the contract. Explain this point. In this case, the plaintiff are the ship rights who are employed by the ship owner of the repairing the woodworks in the ship. But this contract included a clause to their service as terminable at will. Because some of the previous grievances, a few iron workers objected to the plaintiff's employment, where through their representative, the defendant conveyed the warning to the ship owners that they would go on strike until the plaintiff were discharged, resulting in the dismissal of the plaintiff on the day itself. Suppose the union leaders, sometimes they will ask the person, you are not supposed to recruit any person who is not a member of our union. Are you following me?
Yes,
sir.
sir.
Suppose there are two unions are there. What is the necessity that you should join in this one only? AITUC is there, INTUC is there. Why he wants to join? He wants to join wherever he likes it. Are you following me?
Yes, sir.
One is a
Yes,
communist
Yes, sir.
party, one is a communist party, another is a
The capitalist party.
Congress. So it is his will. He can join over there. Can you, one of the trade union will force another trade union member if you don't dismiss him that we are going to make a strike? No. But they can do
No,
so.
sir.
They can do so only at the time they want to improve the salaries of the employees. Yes, if they want to improve the salaries of the employees, yes, he can go for the strike and induces all the workers not to go for the job. Yes, that is okay. It is not a amount to the inducement, no. Because what the trade union is doing is protecting the interests of the employees. Am I right? Am I right?
Yes, sir.
Yes,
Yes,
sir.
sir.
One of the cases, let us see in this case law. Genu Ganapati versus Bhalachand Jivraj. In this case law, the particular A filed a suit against B. Okay, very good. With the allegation that B throw a suit against A and C. See here, A filed a suit against B with allegation. What allegation? That B, allegation through B, B throw a suit against A and C. So allegation was the suit between the A and C, and he filed to the one of the party B, who A has produced a breach of a contract between A and C. What the inducement he did it? You break the contract of the between A and C, who A filed a suit against B because B made such an allegation. So prevented A from the performing the contract which he held with the C. However, it was found that B and C were having another contract regarding the same subject matter. And what B has done was to enforce his contractual right. The result of the B suit was that A was not able to reap the benefits of the contract with the C. The court held that A had not been prevented from reaping any benefit from the contract, but not from performing the contract, and therefore B was not held liable for the interfering with the contract of business of A. See, if this case law, if you write it now, it is very difficult for you to understand it. Because you cite that case law where you could understand very nice way. Are you following me?
Yes,
Yes,
sir.
sir.
No.
Okay, sir.
Better don't cite this case law. I will give the another case law, and which will give the clear idea how it can be done. Yeah, this is a very clear idea. This is a Bremilo versus Casson case law. See, this case law clearly will understand what is what going on here. In this case, it was held that the action of the members of the Actors Protection Society. There are Actors Protection Society is there. Film actors were justified in inducing a theater manager. Yes, they induced the theater manager to break his contract with the plaintiff. One plaintiff is there, as he paid the chorus girls such a low wages that they were forced to resort to prostitution. So now the question comes over there. He made the inducement to remove a particular girl, a chorus girl, and who is working under the theater manager. His contract with the plaintiff, and he paid the chorus girl such a low wages that they were forced to resort to the prostitution. If you pay the low wages in the theater, naturally these girls wants to become a heroines. So what is the short way to earn the more money and the more glamour and to induce somebody else is only the flesh trade. So another example for the justified here, why he induced the theater person to remove a particular girl, chorus girl, tell me. Tell me. She was indulged in the prostitution to get the money. And she was using the shortcut method to reach to the success. Are you following me?
Yes, sir.
So that is the reason
Yes,
the
sir.
trade union artists, they say, you remove that girl. Of course, either you can increase the money also. You can increase the money. Of course, it is attitude. Of course, somebody will increase the money also. They will end in their same activity because they want to shortcut methods. So now, it is not a question of inducement. No, it is not the inducement here. Because whatever their association doing is to keeping the prestige and the status of the people, actors, those who are acting in the theater. Am I right? Say yes.
Yes, sir.
So another example, justified action can be a father. Here, the same example I told you earlier. Father trying to pursue his daughter for making a breach of a contract of a marriage with a scoundrel. Why the parents wants to make a breach of a contract, inducing the daughter? Tell me.
Because they want to secure their daughter's future.
Here I clearly mentioned why the parents are inducing the daughter not to make a breach of a contract. Why?
He's a scoundrel.
Scoundrel! I wrote there, you are not. He's a scoundrel. Who is a scoundrel? A
A
wicked.
wicked or son. Someone who does evil deliberately.
That person is, what is that? Saladam, Durjan, Drust. So, you know it. Sir, whether it is a love marriage, sir, whether it is arranged marriage. If the arranged marriage will be there, why the father will make such a thing? Because he will not choose the scoundrel. Are you following me? Are you following
Yes,
me?
sir.
That
Yes,
means
sir.
Yes,
if it is a
sir.
love marriage, that's why it is a love marriage. That's why the father told that fellow is a scoundrel, and please try to avoid the marry with him. So it is not an inducement. It is not the inducement for the breach of the
Inducement.
contract. Okay. So exception to this rule. The exception to this rule was created through the English Trade Dispute Act 1906. As per the Section 3 of the Act, a sole ground which indicates that the Act was promoting the trade dispute would not be actionable is that it induces some other person to break a contract of the employment, or it is interfering with the trade, business, or employment of some other person to dispose the capital or labor as he wills. So sometimes it is not about to the inducement, because the Trade Union Act 1926, especially Section 18, Subsection 1, Indian Trade Union Act. Here I made it. Section 18, Subsection 1, that the immunity from a civil suit in certain cases. Yes. What? No suit other or legal proceeding shall be maintainable in any civil suit against any registered trade union or any office bearer or member thereof in respect of any act done in contemplation or furtherance of the trade dispute to which a member of the trade union is a party on the ground only such act induces some other person to break a contract of employment, or that in interference with the trade or business or employment of some other persons, or with the right of the some other person to dispose of his capital or his labor as he wills, because they want to protect the interest of the employees. That's why trade union, if they induce any person, it is not amount to inducement of a contract, because they are protected under the Section 18, Subsection 1 of the Indian Trade Union Act of 1926. Is it clear?
Yes, sir.
Even
Yes,
the
sir.
management will not touch the trade union leaders. If they work or may not work also. Are you following me?
Yes, sir.
Because generally they wander from here and there and they will do the business, they do the things, and they will make the liaison between the management and the employment and the employees. So they do the many things, no doubt. Of course, there are good also there are bad also there. Okay? Okay?
Yes, sir. Yes.
So
Yes,
now
sir.
let us see the intimidation. So that is about the case about the inducing the breach of a contract. So in intimidation, the second offense comes under these 5 offenses. So intimidation is an established thought, the threat of doing an unlawful act for compelling a person to do something to his own detriment, injuring or harming himself to the detriment of someone else. So here, harming a person and getting the inducement for the sake of it. So let us see how the intimidation will work over there. So the famous classical case law is Rooks versus Bernard. One of the case law we studied, Bernard versus something we read it. Do you know what is the next name of the case law? We studied the case law. Running versus Jendal. That is about the contract case where the minor is not held liable. But under the tort case, a minor is held liable. What is the name of the case law? Where the tort, a minor is held liable because a minor will not be protected on the tort. What is the name of the case law? The same thing. He has taken the mare, that the female horse, and used it for the lurking or jumping. Consequently, horse became pale and died. And he filed a case against that. The defense is taken by the I am a minor, hence it is not a motor. Minors' contracts are wide, but the minority will not be used as a shield. It can be used as a shield, no doubt, but it cannot be used as a sword. What is the name of the case law? If you know it, you tell
Pass
me.
on,
If
sir.
you don't know it, you say pass on.
Pass on, sir.
Bernard
Pass
versus
on, sir.
Huggies. Bernard versus Huggies. That is the case law. Please, no case law.
No tort law, no case law.
No tort law, no case law, no case law, no tort law. Vice versa. So here, if the Rooks versus Bernard is an important judgment recognizing the tort of intimidation, where a person be threatened to act as a manner injuring some third person. In this case, the plaintiff was employed as a draftsman. Who is a draftsman? He is a plaintiff. Do you know what is a draftsman business?
One who plans a house or something, sir.
See, he prepared the sketches, surveys, drawings, he will make it. That's called man is a
Yeah, yes, sir.
draftsman. Designing. In the design office of the British Overseas Airway Corporation, BOAC. The BOAC Corporation is a draftsman and design man and is a plaintiff at London Airport. Okay, very good. The defendant are the officials of the registered trade union. These people, the trade union people. What is the association? The Association of the Engineering and Shipbuilding Draftsmen, AESD. AESD is the organization, it is an association or trade union, and the BOAC is the company where this person is a draftsman and the plaintiff he is. All the members of the union were in a contract with the BOAC that they will not resort to any strike if any dispute arises. All that members of the ASIC are the BOAC members are the members. The employees of the BOAC are all the trade union members of the AESD. The plaintiff resigned from the membership of the union. The plaintiff in the beginning he became a membership of the union of AESD, but after some time he resigned from the membership of the union. What is the union? AESD. What is AESD? Association of Engineering and Shipbuilding Draftsmen. So The question comes over here is, he resigned from the membership of the union and refused to join the same on the pressure of the union, trade union. His refusal to join resulted in all the members of the union passing a resolution and informing the BOEC, that is the company, the airport, and if the plaintiff was not dismissed, the BOEC members of the ASD union will withdraw their labor. So they threatened it because he resigned from the membership. Let the plaintiff will be terminated. Who said? Who said? Who said?
AESD.
AESD, sir.
AESD trade union member said. So now what did he? He refused to join the resulted all the members of the union passing a resolution and informed the BOEC that if the plaintiff was not dismissed, the members of the ASD union will withdraw their labor. They will ask them to withdraw their labor. They want to make the strike. As the BOEC was informed the resolution by the defendant, the corporation assented to the threat and dismissed the plaintiff after giving the due to notice to him. So whatever that they did it, plaintiff was sacked away because of the intimidation of the AESD trade union. Can a plaintiff bring an action against the AESD, or can a plaintiff bring an action against the BOEC? Yes?
Yes, sir.
Answer,
AESD,
no.
sir.
Because a employer can show the ground to terminate you. So an employer can give the notice to you, terminate you. Here he has given, you did not observe it. The corporation assented to the threat and dismissed the plaintiff after giving him due to notice. Means due notice will be given to him to termination. What is there in the employment contract? Sir, మేము ఇంకా చదువుతాను కదా సార్ మా ఎంప్లాయ్మెంట్ కాంట్రాక్ట్ మాకేం తెలుసు సార్ ఓకే ఐ విల్ టెల్ యూ either you give 1 month notice or in lieu of 1 month notice you have to pay 1 month salary. It is especially for the teaching contracts. Or some contracts, no, you are not supposed to break in the middle of the semester. You have to complete the semester, then you can resign or you can go for any other job. In some 3 months notice should be given or 1 month salary should be paid. That is the deal. So here, what the company, BOEC company did it, they gave the notice to the 1 month or 3 months notice to him and later terminated his services. So he brought an action against the defendant by wrongfully inducing the BOEC in terminating his services. The House of Lords held that the threat of withdrawing labor if the plaintiff's services are not terminated constitute intimidation, and since the plaintiff suffered thereby, he was entitled to succeed in his action. Okay. Now here is entitled to succeed in an action. The reason is, if the proper notice is not given over, so the proper condition is not over there. Because whenever you are terminating somebody's services, you have to show the reason. Are you following me? Are you following me?
Yes, sir.
Suppose without the proper reason that you have not given to him, of course, if the reason is there, they can remove it without any fault of it, of the employee also, by giving the serving the notice. But the House of Lords, they said it, because it is a malice in the part of the, because that fellow was the member of the union first. Later he resigned as from the membership. So, can a person will be punished if he will not be a member of a particular trade union? Suppose if the company is having the 2 trade unions, can the company will remove the other trade union all members? Tell me.
No, sir.
Answer, no. If the strong reason would be there to remove him, yes, they can remove him. Okay, if there is a provision is there clearly, yes, a person can be, services will be removed without any cause by giving the notice, yes, he can be removed. No doubt at all. So here, what actually the intention? You know the whole story of this. That fellow in the first beginning, he was a member of the union. Later on, he resigned the union, but they pressured him to join the union. He did not join the union, and they pressured the Boeing company to terminate him. But Boeing company, after some time, they assented and terminated him. And this fellow, he went to the court because of the intimidation. He brought an action. Who means plaintiff? Brought an action against the defendant. Who defendant wrongfully inducing Boeing? Defendant. Who is the defendant here? AESD. Are you following me?
Yes, sir.
The AESD induced whom? BOAC. So the plaintiff bring an action against the defendant for wrongfully inducing the Boeing in terminating his services. The House of Lords held that the threat of withdrawing labor if the plaintiff's services were not terminated constitute intimidation. And since the plaintiff suffered thereby, he was entitled to succeed in his action. So, if the Boeing has shown the reason for the termination, the House of Lords will say it is not amount to intimidation. Am I right?
Yes, sir.
Like the parents have shown the strong reason for the breach of a contract with a particular person. What is the strong reason?
That bridegroom is a scoundrel. Scoundrel.
That fellow is a scoundrel. That is a strong reason. Are you following me?
Yes, sir.
Here also the company shows the strong reason for his termination. Naturally, the House of Lords also says that it is not intimidation. So that is a very famous case law where we can say. Another very, very interesting case law. This case law already I told in one of the place. I don't know where you can remember it. Venkata Surya Rao versus Nandapadi Muttaya. This is the case law. Where I taught this case law? Tell me. If you don't know it, you say pass on. Don't waste the time.
Persons.
This case law I told. In this case law I referred in the assault. Assault and battery, while I was saying no, this case law I referred it. Because this case law facts I know it. That fellow has due of the revenue. For the revenue collection, who will come? Patel and Patwari is there at that time. And they came with the Sheikh Shindi. Because one fellow, like his Jawan, and he came to collect the revenue. And that is the last date of collection. And the wife is locked in the room and she went away for the weeding out. She went away for the weeding out for the casual labor. And this fellow is alone would be there. And the revenue inspector, that fellow came, revenue collector came, and he saw, he did not find anything outside it. And he saw only the one thing, a gold ring would be there to the plaintiff. What is there? A gold ring is there to the plaintiff, because that was the thing. Generally, the people used to keep it out. When the male child dies, they will keep the gold ring so that the male child will not die. That is one of the women. One of the women, or sometimes the place, it's the custom of some people also. Am I right?
Yes, sir.
So they carry the gold ring over there. So the revenue inspector saw it, the gold ring is there. So he thought that let this gold ring serve the purpose in lieu of the due. So they called the goldsmith. The goldsmith came. But the goldsmith came, and the group was, why the people are surrounding it. Everybody came over there and saw what is happening over there. So a good Samaritan said, okay, because this fellow, how much due? Okay, this much due is there. So that good Samaritan has paid the amount, and the revenue inspector went away. Now this fellow, who is the due, he bring an action against the revenue department for the assault or for the battery and intimidation that he did. Whether it is amount to intimidation, number one, whether it is amount to the assault or battery, number two. Now you tell me. I have given the total picture of the whole background of the facts of the case law. Tell me, whether it is amount to the intimidation, whether it is amount to the assault and battery.
Assault and battery.
Neither it can
Assault
be
and
assault
battery,
and battery, nor it can be intimidation. Because before the intimidation happened over there, a good Samaritan has come and paid his amount. So what the case law say? An agriculturalist pleaded that he was unable to pay the arrears of the land revenue, for which the village munsif threatened to distrain the earring worn by him if no other movable property was readily available outside. The village goldsmith was also called for the same, but on his arrival, one of the villagers made the necessary payment. Means villager means a good Samaritan, a good man came and he has necessarily payment he made. It was held that there was no intimidation in this case, since the threat was not to do something unlawful here happened, had not compelled the plaintiff to do so something to his own detriment, because detriment of somebody else is more important factor over here. But that no detriment is made towards the plaintiff. Any threat was made against the plaintiff?
No, sir.
no sir,
No. A good Samaritan came to the rescue. No threat was made, no intimidation was made, and no assault is made, no battery is made. So it is not neither it is an assault, nor it is a battery, nor it is a criminal, or nor it is there was no intimidation at all. Now let us see what is the intimidation under the criminal law. The criminal law 503 of the IPC clearly says what is intimidation. So if there is an intimidation to threaten somebody else, yes, we can say it is an intimidation. Otherwise, we cannot say it is an intimidation. The example is very much clear. A threat delivered by the C to B, whereby C intentionally causes B to act or refrain from acting either to his own detriment or to the detriment of D. The essence of the wrong is an unlawful threat. The threat would be compelling a person to act his own detriment or to the detriment of some third person. The example of the intimidations are where a person may be compelled to act or to his own detriment or by the threatening a person with the violence if he performs a particular contract, continues a business or passes a particular way. If there is a threat would be there. If a person does, yes, we can say there is a criminal intimidation. Because a person keep a revolver a zero distance on the kanta of a man. Tell me what is the kanta of a man?
It is called as temple in English, sir. Temple.
The temple of a man. That fellow says what? Batikunte balasakaina?
Tini batakochu.
That fellow gives the consent and does the work. Whatever he says. Who? A person who is keeping the gunpoint. That is a criminal intimidation. That is the criminal intimidation. The intimidation where a person may be compelled to act to his own detriment. Own detriment. Amutava amma ani chenu amutanu. Own detriment by threatening a person. Itla how? By keeping a gun, road gun with a violence. If he performs a particular contract, that fellow what he does, he definitely will perform a contract. He will sell the land to him, and that is called intimidation. Okay, is it clear?
Yes, sir.
Now let us see the conspiracy. This is the third one. And you know what is the section deals about the conspiracy in the IPC? It is the famous section. Sorry, first semester.
Pasan, sir.
ఓకే చీటింగ్ చెప్పండి
420.
చెప్పండి
420, sir.
420
420.
మరి మీరు చదివినరా అండి మీరు 420 కాడికి వచ్చినరా అండి
విన్నాం సార్ ఢిల్లీ
మరి
లైఫ్.
ఎట్లా తెలుసు అండి ఇది పీపుల్ ఆర్ మెనీ చీటర్స్ ఆర్ మెనీ అరే వాడు 420 రా వాడు అంటారు
జనరల్ నాలెడ్జ్.
అరే వాడు 420 రా అంటే అర్థం ఏంటి తెలుసు కదా చీటర్ అన్నట్టు
ఎస్ సార్, చీటర్.
That means
సార్ సెక్షన్ 120A అనుకుంటా సార్, క్రిమినల్.
ఇది 120A క్యాపిటల్ A 120 క్యాపిటల్ B capital 120A and capital 120B. So an act where two or more persons without any lawful justification come together with the sole purpose of willfully causing damage to the plaintiff, other than actual damage result therefrom, this would result in the thought of conspiracy. Merely two persons doing the same act is not conspiracy. No. Two persons willing together with the common intention and causing hurt to a particular person, then we can say it is a criminal conspiracy. And an actual damage results therefrom and would result there of the tort of conspiracy. Let us see the tort of the conspiracy is known as the civil conspiracy, and a conspiracy can be termed as a tort as well as a crime. The conspiracy is both a tort as well as a crime. So, essentials of the tort of conspiracy, let us see that there are two or more than two should be there. What are the ingredients? Three ingredients are there. There are three essential of the tort of conspiracy. Number, the presence of the intention is the first and foremost. There should be some intention. Number one, for the tort to become a conspiracy, the presence of the common intention to harm the other person is must. If the sole purpose of the combination of the to defend, to trade, or those who enter into the further trade are not to injure any person, that no wrong is committed, no action will lie, although damage has been incurred by the complainant. If there is no common intention to be there, if any damage is caused over there, it is not said to be the conspiracy. The aim of the purpose of the coming together or combination must be cause damage to the claimant. However, the degree of the intention to harm may differ. In the presence, its utmost importance. So common intention is very much important factor over there, and that causes the damage. The second essential element is the combination, which refers to two or more persons coming together with a common purpose or performing the constant action. Number one is the common intention. Number two is the combination of the two or more persons for the common purpose. It's a very important factor. So the mere presence of the similar intention without any combination is not enough for the tort of conspiracy. If the two members are there, but there is no common purpose, there is no common intention is there, then we cannot say it is a conspiracy. Let us see the example. You read the example here. Read this example.
For example, two different persons, Mr. X and Mr. Y, having the same intention of harming Mr. W, cannot be held liable under conspiracy as they were not combined together, even though having the same intention. With the same intention, both the persons have combined together and Mr. X is guarding the door, whereas Mr. Y proceeds to harm Mr. W. Then this will give rise to the tort of conspiracy.
Yes, see, this distinction is very much clear here. See, merely two persons doing it with a common intention is not enough for the conspiracy. There is a two member common intention with a common purpose should be done over there. The example is given. Two different persons, X and Y. Okay, very good. Having the same intention. What is the intention? Harming W. Are Vani Thanalra. Everni W ni. Everevaru X anukunnadu, Y anukunnadu. Is it a command of the conspiracy? Individual X antadu, individual Y antadu. X ivaladu antadu, Y rendo roju antadu. Or X podugaladu antadu, lekunte Y sayankalam antadu. The common intention aitadandi. And conspiracy aitada idi. They say Kannadam is there. Okay, he wants to kick it. Okay, they kicked it. But cannot be held to be liable under the conspiracy. The conspiracy gaadi idi. X will be held liable if the kicking is not justified. Y is held liable if the kicking is not justified. They are not combined together even though they are having the same intention. They combine together with Tanle Valaku. Podugal Okadanindu, Sankar Okadanindu. Or Ival Okadanindu, Repo Okadanindu. Am I right? Am I right?
Yes, sir.
ఎప్పుడు కాన్స్పిరసీ అవుతుందండి? ఇప్పుడు చెప్తాను. ఇప్పుడు చెప్తా కాన్స్పిరసీ ఎప్పుడు అవుతుందండి. If the